Hi, everyone. Welcome back to Note My Objection. I'm Catherine Loftus. Tonight, we're going to be talking about the continuation of the motion to compel Colin Albert's deposition and document production. And remember, when we talk about deposition notices and document subpoenas that go with them, it's sort of two-pronged. One is compelling the testimony, and one is compelling the production of documents. And so I think we're having sort of two different conversations here that need to be clarified about all these motions to compel. What we heard from Attorney Rosenberg during the hearing, that there were going to be additional motions to compel filed of I think it was Nicole Albert, Brian Albert, and maybe one other non-party. Now remember, this is the wrongful death suits. These are not parties. These are third-party deposition notices. So when we were in last week, Jim Tuxbury, who represents the, either one side refers to them as the House defendants, the other side refers to them as the Commonwealth witnesses. And so their position essentially was, listen, there was a notice of deposition sent out in February. It's their position, it's the plaintiff's position and the third party's position that the deposition was canceled by Karen Reed's attorneys because they didn't have the documents in time. And it's Rosenberg, Karen Reed's attorney's position that in fact, it was not canceled, it was rescheduled, and therefore is still like a live subpoena. And essentially, Judge Gildea was like, you need to figure out how you're gonna get Colin Albert here to Tuxbury. And he went on like a rant towards Rosenberg. This is the one where we talked about that he essentially told them stop pandering to social media and making everything sensationalized. And there was a lot of discussion about who that was directed to. And I know people like to think it goes both. Of course, he's saying it to everyone, but in my opinion, from a legal perspective, it's clearly targeted and directed at Reed's team. So we were in last week and they essentially were like, let's come back. The judge was like, we're gonna come back on Monday because he's been assigned to this case to keep it on track. Now in federal court, it's much more, it's like hardcore tracking order. You can get judges down there that are like, this is the trial date unless one of you dies, we're going to trial. So like, you better get ready, whatever you need to do to get ready. And this is what Gildea is trying to do here because he doesn't want to have a trial date in 4 years. Did you just hear that upstairs? He wants a trial date soon. It's been pending since 2024. It was stayed for some time. And so he's having them in like literally every 3 days to make sure they're on top of it. Now their discovery deadline ends in August. So the issue is that if Colin Albert's deposition were to be taken outside of it, that's outside of the scope of the discovery schedule. And so I'm going to go through kind of like what we actually heard from the parties today. Lucky for you, again, I have my trusty notes. So basically Gildea said to Rosenberg, what I see is you really have the questions. There's two issues about documents that you're looking for relative to Colin Albert. One are his communications with his parents, and two are communications with everybody else. And he said, yes, sort of, yes and no, but Karen Reed's attorneys are requesting essentially all communications within a small period of time, January 28th, 2022 through April 30th, 2022 was their last proposal, is what he said. And the issue is really about the scope of the subpoena request, right? Because at first they asked for 4 years of everything, and obviously it's been limited. But what you'll see is the sides are taking two different kinds of positions. So Rosenberg appears to be limiting the time, but he wants more communications. And Attorney Maddie, who appeared on behalf of Colin Albert on this case on Monday, because he is his attorney in the defamation case, and the judge basically was like, it doesn't matter. You're all usually, like we talked about last time, you have to be pro hoc vice, which is a whole process that you have to like file with the court and the BBO. You get a registration statement, pay the fee, all that kind of stuff. But the judge is just like, whatever, like you're gonna be essentially, because it's ridiculous to have to go through all of it for separate cases when all the parties like cross sides. You know what I mean? So Maddie appeared and said, first he was like, I'm not on the email that Rosenberg had sent to the court and all the parties like as the latest status update that morning. So they took a quick break. Maddie was like, I'll take a peek at it just to review. And then essentially said, like, I did know, like, the substance of it. I just wasn't on the actual transmittal to the court. So the question from the court is, to Rosenberg is, can you, like, you can't limit the scope of that at all, because what is the relevance? You know, there is a relevance argument, and that you can't just get anything you ask for. Like, there is a limit to what documents you can actually be provided and you can compel to be produced. The court says to Maddie, is your proposal in the scope of your request from all of it to less communications? And what Maddie says is, ours is broader and covers a bigger picture. So it's 3.5 years. Like, we're willing to give you 3.5 years of anything that has to do with the death of Officer John O'Keefe and the investigation, right? And he said, you know, we can do search words, we can do search terms, we can figure them out together, like Attorney Rosenberg and I. And Rosenberg actually said later, like, you know, search terms can be very relevant and helpful. And essentially what he said was, we're willing to give the same amount over for all of these witnesses, because these are going to be the forthcoming motions to compel, right? In that the way we look at it is what they are entitled to are communications relative to this, anything that would have to do with the underlying substance of this case, which is wrongful death and infliction of emotional distress. Now, Rosenberg says essentially that part of their emotional distress claim is like that his client presented a false narrative, so therefore they shouldn't just be limited to the death of John O'Keefe, which I do understand that argument, right? Because it's not just a wrongful death case. It is also an infliction of emotional distress claim. But then Maddie was like, you know, if you think about it, right, like, at the same time, this is an individual who is suing the client in this case, the defendant in this case, Karen Reed, and Aidan Carney for defamation. And of course, there's going to be conversations about them. Like, if someone's harassing you endlessly, like, of course you're going to have text messages with your parents and your friends about them, you know? And I think the underlying concern here, which, like, nobody talked about it out loud, is that, like, if there are, like, private communications that aren't otherwise relevant to this case but are produced, I think there's a fear that they'll make it onto the internet, and from one side and not necessarily the other, and that they'll be used as, like, further fodder for defamation, right? So that's what I imagine Chris Maddie is thinking, like, right? That, well, if more comes out and it doesn't have anything actually to do with anything, but, like, a certain group is going to take stuff and just, like, further harass, you know. And he talked about this. He said, you know, our proposal, which, you know, we can come up with this, like I said, the search words together should encompass everything. So let's look at, you know, look up Proctor, look up, you know, Good, look up John O'Keefe, look up all that kind of stuff, anything that has to do with the investigation, and they'll broaden the search terms. And he said, even in, like, the parallel universe, that's what he called it, the parallel universe where John went into the house, that their proposal would capture that, right? That their search word proposal and what they're saying is, like, a really broad scope, but relative to certain issues would cover that. And essentially says, you know, the defendant wants all the text messages referencing her, Karen Reed, like, so they want anything that they said about Karen Reed, which I'm sure is not good. Like, let's be honest, like, you've been accusing them of murder for 4 years. Like, the text messages about you are not going to be nice, but that's not really relevant to this. Do you know what I mean? So, and I know people say it will, but if you operate from the assumption that, if you think about it this way, like, number one, do we think there's a likelihood that there's, like, active texts about conspiracy on text messages? I think that's very unlikely. Do we think that there's a lot of shit talking about Karen Reed by any of the Alberts and the McCabe's? Of course. Like, would we expect any less? She's talking shit about them and saying they murdered everyone. And so I'm sure that they're talking shit about her on their family text messages. You know what I mean? I can't imagine that. And so we're in this like weird land where we have this civil case, but there's just like so much outside noise and persuasion that it's hard to sort of separate everything. But, so Rosenberg says, if there was a text, right? He says if, and he says, I'm not saying there is, but if there was a text that said, get rid of your phones, that wouldn't be captured. Now, if somebody ever writes, get rid of your phones on a phone, they deserve everything that comes to them. Okay, I'll tell you that. But so the question is like, you certainly can fashion some sort of limit to the scope of the request and maybe broaden the search terms so that everything would get encompassed, right? Otherwise, you just like, you get a third party's just text messages for years is crazy. Even for 3 months is crazy. It's, I don't know. I think the scope of it has to be limited. I don't think Gildea is going to order like all communications for a certain period of time. I think he'll limit the scope of it. So that's my prediction. Then next they talked about the availability of Colin Albert. So remember, 2 parts to the deposition and the subpoena is one is the appearance, okay, so the actual testimony, and number 2 is the documents. So we just talked about the documents. Now we're going to talk about when and how is he actually going to get here and get back. Now the court asks essentially, have you made any inquiries? Like, what have you been doing? And Maddie says, we've asked the U.S. Army, Fort Jackson, where he is. Like, we've done some research into what the process is to get somebody who is in essentially basic training at the time, and that he is under the commander's control while he's in basic training. And so the question is like, how do you actually get him back? You know what I mean? So this is where sort of like reality comes into play, because it's not just as easy as you think, like, well, make him come back. I mean, I don't think the judge is going to order him to leave the Army. I would guess that's not going to be what he says to do. But there has to be some sort of mitigation like in the middle, because I do understand the frustration of like, okay, we want to depose this person and now they're unavailable, completely unavailable. And we didn't want to depose him when he was being deposed by everybody else because we didn't have all the documents. And it is for any party who's deposing someone, you want the documents beforehand, like that, of course. So I do understand that. But I do think there is sort of mitigation from that. There was originally a subpoena sent in February and he was ready to sit on April 29th. So like to say he's running away from it, it's like, well, he was ready to sit and you served the document subpoena a week before the deposition. So like you knew what was going to happen. And then you didn't, so the argument is, they said they were going to reschedule it. So did they renotice it? Like, did they have any communications? It doesn't seem like there was any communications, like affirmative steps on Reed's defense to reschedule the deposition. Probably because they're dealing with this document stuff. But it's kind of hypocritical to be arguing about the document stuff. And then at the same time, we hear at the end of the hearing that Karen Reed is being deposed on Wednesday and hasn't produced like half of her documents. So, you know what I mean? It's like, what's good for the goose is good for the gander, is supposed to be. Rules for thee, not for me. It's this is how it goes. Like in court, you have lawyers who get up and like make an argument on the other side, like make the opposite argument against the same thing that you just stood for. So essentially the court's like, listen, but what are we actually going to do? So Maddie says that he needs consent of the United States Army because the U.S. Army has custody of Colin Albert. He called the staff JAG at Fort Jackson, JAG, I'm sure most people know is the judge advocate. That's what the lawyers are called, the prosecutors are called essentially in the military, and left 4 messages essentially being like, we have a civil case in Massachusetts and one of your recruits is subject to a subpoena and we need him to testify. Called 4 times, left 4 messages. He said he consulted with a colleague who was a former JAG, had 2 combat deployments, and basically said you're going to need the permission of JAG and the Army Litigation Division, which is like the division that handles all the legal stuff for the Army. He said, he's in basic training 4:30 a.m. to 9 p.m. He gets 1 phone call a week, and it's a 10-week program, and he'll be granted leave after that. So if he went in the beginning of June, maybe second week in June, did he go in? I'm not exactly sure of the date. But that would put us like very shortly after the end of the discovery schedule. And so Maddie was like, I asked Rosenberg and all the other parties if Judge Gildea would allow a request for a very brief extension of the discovery schedule just for this specific purpose. Would you assent? And all the other parties assented and they didn't. And so it's just, I don't know, it's just a lot of like, I find that civil court, there's a lot more games played. I don't know why. I really don't know why. I find it more difficult than criminal stuff. I feel like criminal attorneys like really just vibe together a little bit more. Not everybody, but I think in any real world, if this was not the Karen Reed case, I think 100% Attorney Rosenberg was like, yeah, no problem, we'll depose him in September. I mean, I would bet a very serious amount of money that if this was not the Karen Reed case and that was not Colin Albert, that he would have sent to a motion to take the deposition, to extend the discovery schedule for a month to have a deposition of an active duty recruit, U.S. Army recruit. But because it's a Karen Reed case, and this is everything with these cases, the criminal cases, the civil cases, like nothing is normal. Nothing comports with like the standard local practices, procedures, all that kind of stuff. And, but I will say, so that's Maddie's position. Basically, like, I'm trying everything. I don't know what to do. And I will continue to try. And if the court like orders me to tell the Army that A, B, C, or D, I will. But like at the end of the day, I cannot physically like get him out of I can only do as much as I can do. And, the court said, but didn't he create this burden himself? Which is essentially what Rosenberg then, he sort of agreed with that position that the judge, asked Maddie. Like, okay, but he knew he was scheduled for depositions. He knew he was going to be having one upcoming. He knew all this kind of stuff. Shouldn't there have been like, yes, do I think there should have been more? Do I think the attorneys should have been notified beforehand that he was going to let go? Yes, because this could all be avoided, and this just causes more delay and drama and all that kind of stuff. So do I think, yes, like Colin Albert should have gone to his lawyer before in like March, April, and was like, I'm planning on enlisting, so once I sign up, I'm going. You know what I mean? Instead, it was like, oh, I enlisted, I'm going next week, which is, it is a difficult situation because if people's schedules don't work. But so the court's like, didn't he create the burden himself? And Maddie was like, listen, but why is it fair to put the burden on him? Like, he's been here for all these years. This case has been pending since 2024. It's the middle of 2026. Like, he's been here the whole time. They've never, they didn't notice his deposition until February, and then they rescheduled it. They never asked for another date again. And, so the fact that he's going to enlist in the military is going to be used against him. And he talked a lot about, because it's all about when you are asking them things of the court, what they take into consideration is not only the substance of the request, but also whether there's going to be prejudice to any parties. And that's what Maddie was like, what is the prejudice in like a delay of 3 weeks? Okay, like honestly, they didn't want to take it. They didn't want to take it now anyway. It's going to take us this much time to get on board with the same agreement about the document request. So we're probably going to be well into August anyway. Like, it's not like he's coming home and they can't even agree to the documents yet. So like realistically, they haven't agreed to the scope of the document request. So until they agree to that, and then they have to do the search and turn it over, you know what I mean? It's probably not going to be till August anyway, so they're going to have to ask for an extension. So I think what likely is happening is Gildea is just making sure that Tewksbury and Maddie do everything that they have to do. So for the record, they went through all the steps, and then he's going to say, you know, all right, I'll let a brief extension to, that's what I would guess. I don't know. And, you know, because essentially, I think the prejudice argument is fair that Maddie's like, what is the prejudice? Like, what is the actual prejudice? What, you need to take it in July versus first week of September? What's the difference? Substantively, what's the difference? Especially if he's not even, it's not like he's watching social media or paying attention to things or anything like that, you know? And he's like, we could take it 3 weeks after the deadline. And Gildea went in this little, he's like, yeah, I really don't know what their strategy is, but he's interested in this whole, I think, like, debacle. But basically, Maddie said, if the court tells us to pull him out of the Army, we will do that, but we don't think that's fair. And I don't think the judge is going to do that. I don't think the judge is going to do that. And so essentially they just went back to, you know, Rosenberg sort of reiterated that this was a self-imposed burden. Like, he could have notified people more and with more timing, and they could have, you know, they could have figured other things out. But so they put this over. Essentially, it's sort of in limbo right now while Maddie, Tewksbury figure out what to do with, see if that JAG lawyer. I would bet, okay, so here's a little bit of like inside baseball when it comes to getting the feds to do anything. Good luck. Good luck. Good luck. Good luck. The feds don't care about state court. Nope, they don't. They won't listen to an order. I will tell you how many times we had witnesses or defendants who were in federal custody. You know how hard it is to get someone in federal custody into a state court? It's virtually impossible. They literally don't care. I swear to God, they literally don't care. The feds don't care. That's why I don't trust the feds the most, because nobody polices the feds, and the feds do literally whatever they want. So I wouldn't be surprised if the JAG never returns Chris Maddie's phone call. Like, that wouldn't surprise me. It wouldn't surprise me. Hopefully he will, but he's probably gonna be like, sorry, bro, I don't know what to tell you. Nothing we can do. No, we're not gonna let him sit for a deposition. No, we're not. I bet they won't. I bet they won't. I bet they won't even entertain it, because it's not even like it's a, you know, he's not a witness in a criminal case. They're like, it's a civil, he's a non-party in a civil suit, and you want me to order him, you know, take him out of basic training to sit in a deposition for a day? Absolutely not. That would be my guess of what the U.S. Army is going to say to Chris Maddie. And then Chris Maddie is probably going to relay something along those lines. I mean, you know, they'll dress it up a little nicer. They won't say it quite like that. But, and so I would bet at the end of the day, we're going to see a deposition of Colin Albert when he comes home from boot camp. And that's going to be like early September. So they went into a little bit about what else they have, because they're back at 9:45 on Friday. And then they have dates after that. I don't even remember what all of them are. But basically, what else to come is motions to compel about Nicole Albert, Brian Albert. This is going to be essentially the same thing. So that's why Chris Maddie was like, we will agree to the 3.5 year period if we can limit the scope. But, and that's to all the witnesses, Colin, Brian, Nicole, everyone. I assume Jen McCabe, Matt McCabe. I'm forgetting who's named in what lawsuits at this point. So those are out 9A. So that means that Karen Reed's team has sent motions to compel production of documents from Nicole Albert, Brian Albert, and whoever else. That means, remember, they sent them to the opposing party, who is the plaintiff in this case, and will be for the third party, into the third party witnesses, because that's who the motion to compel is subject to. Then they have 10 days to file an opposition, 10 days plus 30 days for mailing, so technically 13, and then the entire 9A package, which is the motion and the opposition together, gets filed with the court, and then they argue about that. So they might just argue about it on Thursday. Like, literally, I think Gildea, he's like skipping these 9A. He's like, oh, you know, Rosenberg will be like, oh yeah, that's 9A, so that's come next week. And he's like, well, let's talk about it now, because everybody knows the issues. Like, we've talked about what 9A is. That's to reduce the burden of the court and to just send everything in once it's ready. But like, we know what the issues are. We know what the issues are. It's the scope of the document requests. Okay. Like, so let's just talk about it right now. So that's coming, the motions to compel. Then they talked about, Rosenberg said they had a deposition of Brian Tully scheduled, and they had it scheduled, then the attorney rescheduled it, and then the attorney filed a motion to quash, which basically means the attorney for Brian Tully is coming in and saying, like, you don't even have any right to depose him or get document requests. Now, I haven't seen any of that because, again, that has to be served, the motion to quash has to be served by Brian Tully's counsel on Karen Reed's counsel via 9A. Then they get 10 days, 3 days from now, 13 days to respond, and the whole packet goes in. So we're going to have motions to compel, a motion to quash by Brian Tully's attorney filed. Then the plaintiffs, Daniel Buck stood up. He was... he's handled, I think, what's his name? Mark Dill out of town. So then there's a motion to compel the deposition of Aidan Connie, and then motion to compel answers to interrogatories from Karen Reed. So she's scheduled for a deposition tomorrow, Wednesday. This might come out tomorrow. She's scheduled for a deposition Wednesday and hasn't produced all of her stuff. So there were 53 requests for documents, and there were 34 work product or attorney-client privileges. One of the responses came in October, and then there was a second response, and he said he never got a privilege log. Now, if you claim something as work product or attorney-client privilege, you're supposed to basically make a log about like what you obviously don't turn over what the actual communication is or what the information is, but you basically give like a summary of what it is. So there's a privilege. So if there's an issue, you can't just be like a work product. It's like, well, what is it that you're claiming? And so the court essentially was like, but and Rosenberg was like, okay, we're working on them. We're going to provide them. And he was like, yeah, but the rule says when you claim the privilege, you have to provide a privilege log. So why are we here since October and there's been no privilege log? So that has to be provided. And that's it. So they're back on Friday morning at 9:45, and this will be the never-ending case. It's just never going to go away. It's in every court in Massachusetts, so lucky for you. I practice in them all. Thanks, guys, for watching. If you like this, please share it with somebody. Think about subscribing, and lots more to come. Thanks. Have a good night.
If you like this episode, please comment, like, share, and subscribe. Every bit helps. Thanks for watching Note My Objection. See you next week.